Good afternoon and welcome to our next ABA section of Civil Rights and Social Justice Perfecting Democracy Chair Chat. I am Dr. Cynthia Swann and I will moderate today's session. I currently serve as the Secretary of the Section of Civil Rights and Social Justice, and I am Chair of the Perfecting Democracy Initiative, which aims to recruit lawyers and law students to support nonpartisan efforts to protect fair elections and voting rights at all levels. I wish to thank our CRSJ Chair, Lacey Durham, for her leadership and for the opportunity to continue chairing this important initiative, as well as to moderate these very critical sessions. I am also Chief Administrative Officer of the Hip Hop Caucus Education Fund, where we focus on harnessing cultural expression to empower communities most affected by injustice. And we truly recognize the power of the vote. And for over 16 years and across 7 election cycles, the Hip Hop Caucus has mobilized hundreds of thousands of young BIPOC voters through our award-winning Respect My Vote campaign, fighting against voter suppression and advocating for election system reforms. We are now, as we have been in the past, actively engaged in the voting rights movement. But today, I have the great pleasure of introducing you to a person who has been a friend, a mentor, and a confidant over many years. For those of you who do not know of Barbara Arnwine, and I can't imagine that there are very many in the civil rights and human rights community who have not heard of her. She is the president and founder of the Transformative Justice Coalition, and she is internationally renowned for contributions on critical justice issues, including the preservation of affirmative action and diversity programs, women's rights, immigrant rights, judicial diversity, criminal justice reform, racial profiling, healthcare disparities, LGBTQ rights, and so much more. Prior to Ms. Arnwine's founding of the Transformative Justice Coalition, she was president and executive director of the Lawyers Committee for Civil Rights Under Law from 1989 until 2015, and she is currently president emeritus of that organization as well. During her time with the Lawyers Committee, I find that it is important for us to acknowledge that in addition to many of her civil and human rights efforts, she had the prominent leadership role in developing election protection, which is now the nation's largest nonpartisan voter protection coalition, which launched in 2024 to assist historically disenfranchised persons to exercise the fundamental right to vote. Ms. Arnwine was also fully engaged in the passage of the landmark Civil Rights Act of 1991 and the 2006 reauthorization provisions of the Voting Rights Act. Barbara is internationally recognized for her work over the years with the United Nations in the areas of civil, human, and political rights, and she works tirelessly towards the elimination of all forms of racial and ethnic discrimination. Barbara has received far too many national, regional, and local awards for me to mention here because we do want to get on with the discussion. But she does currently serve as the board vice chair of the National Coalition to Abolish the Death Penalty, and she serves on the board of directors of Moms Rising and Independent Sector. Barbara Arnwine, we thank you for your tireless efforts and welcome you to today's Chair Chat.
Well, thank you so much for having me. Thank you, Cynthia Swann, for all your amazing work that you do. Dr. Swann, you are an amazing leader in this field, and it is my joy to have this chat with you. And of course, I've had the pleasure of serving on various ABA racial justice, initiatives and committees. So this is very important to make sure that our ABA community is being reached. So thank you so much.
And you're very welcome. And also let us not forget that you are a leader within the National Bar Association as well, which is recognizing its centennial this year. And
absolutely
major conference at the Howard University Law School that is the tradition of that centennial. So The work goes on, and the recognitions of all that lawyers bring to the field is in the forefront as we're beginning this fight.
Absolutely.
So, Barbara, during previous chair chats, we've discussed the Voting Rights Act of 1965 as a landmark achievement, the impact of the Supreme Court's decision in Shelby v. Holder, which invalidated the preclearance requirements. And we've even touched on Brnovich and the Democratic National Committee ruling, which made it more difficult to challenge discriminatory voting laws in court. But at this point, I would like for you to please discuss, as a means of setting the direction of this conversation, if there's any lower court rulings or ongoing cases, perhaps less widely covered than Brnovich or Shelby, that you believe will have a significant impact on the future of voting rights. Either cases that will further harm or that will perhaps help reverse the impact of these cases. And please include if you believe Congress's efforts to restore parts of the Voting Rights Act through legislation like the John Lewis Voting Rights Advancement Act are sufficient to counter the impacts of these recent court decisions.
Well, I think probably the most undertaught and understudied decision that I believe is a path-breaking of future precedent-setting decision by the federal courts is that in NAACP versus McCrory. That is the case that people all the time are quoting in shorthand when they're talking about doing something or the other with surgical precision. That is the case out of North Carolina, attacking what was called the Monster Law. And the Monster Law was a series of voter suppression measures that had been cobbled together by the state legislature and passed to basically impair and to impede the participation of African American voters in their elections. And originally, the case, when it was brought not only as a case under our traditional voter dilution principles and our traditional voter denial principles, but it was a case that was also very much focused on purposeful discrimination. And this case is so important because what it showed was how the state legislature had used racial data to determine what laws it was going to pass, and had used racial data where they saw that certain voting patterns and voting procedures were favored by Blacks. They had used that racial data then to take away those particular procedures, where they found out that certain procedures actually impeded the participation of Blacks. They then doubled down on those procedures. I think that if in fact McCrory was studied harder, even by the Supreme Court itself, that the decision in Alexander that it came up with this year would have been different, because they very much, the Supreme Court, I think, misinterpreted and poorly applied the use of racial data by the South Carolina legislature in that case. So if they had actually looked at the Alexander versus South Carolina NAACP, if they had actually looked at McCrory better, I think they would have come out with a much better decision, instead of continuing this confusion over what's partisan gerrymandering and what's racial gerrymandering. But the beauty of McCrory is that it actually talks about how you interpret state legislatures' use of racial data. And that's what the Supreme Court got wrong this year in Alexander.
Hey, Barbara, you've taken us straight to the core of what's happening. So do you see any type of shift in how the courts are handling gerrymandering? if you look at RUCO versus Common Cause,
Yes.
and the role that partisan gerrymandering plays in different disenfranchising minority communities, how do you see all of this playing out?
Well, once again, there are two tranches of legal battles that we're engaging in. One is what we call the vote denial battles. And those are all the battles around where you move polling places, where you reduce polling places in African American communities, where you move them at the last minute so African American voters don't know where to find the polling places, or you make them more inaccessible for those with disabilities. I mean, those are all the vote denials, strict voter ID requirements. All of those things go under the voter denial tranche. Then you have the voter dilution tranche. And the voter dilution tranche is all the gerrymandering cases, right? So when you look at the voter dilution tranche, what you see is the court in the really great decision in the Alabama, what became, Alabama District 2's case, that case that they decided not to, just 2 years ago, was really shocking to most jurisdictions. People did not expect the court to, issue such a very progressive decision. But the sad news is that the court, just a year later, in the Alexander decision, has muddied the waters. It was no accident that after their decision, in the Merrill, case in 2023, that after that case, that you saw Louisiana, do a better job. The Fifth Circuit actually, did the right thing in the holding Louisiana accountable and requiring it to create another majority Black district. You not only saw, that change, actually, Merrill became the Allen case, but in any event, you saw, jurisdictions beginning to look more harder at these racial gerrymanderings. But Alexander, this year, I think, just really confused people, and we don't know the consequences yet of that decision long term, because the question there was, did the South Carolina legislature draw those lines based on racial premises to actually, was it a racial gerrymandering or was it a partisan gerrymander? And the court kind of confuses it. And basically it held that it was a partisan gerrymander. And under, Rucho, et cetera, you have the federal courts don't intervene when it's a partisan gerrymander, which I think is a bad decision, by the way, by the court. Because if you look, no, seriously, if you look at the Pennsylvania state Supreme Court and other state Supreme Courts, they've taken on this issue of partisan versus racial gerrymandering. And they have held that even partisan gerrymandering is a violation of state constitutions, that it does not afford, the principle of one person, one vote, that is purposeful interference in the ability of voters to actually choose, elect, legislators and elected officials of their choice. So the lower courts, it's the state Supreme Courts, I should say, have been much better on this issue than the Supreme Court. So I challenge even Rucho. I challenge, the rationale of that decision. And I think that ultimately, if we're going to have a real democracy in the United States, that decision ultimately will fail. I think that the court just put up a lot of, constructs and made it more difficult for itself in reaching, a good opinion. But that confusion coming out of Rucho has affected Alexander. And right now, what you're going to have is a whole lot of jurisdictions drawing, very bad racially, targeted districts. And they're going to be saying, oh, well, it was just political. I was just, all I was doing was just trying to keep a party, incumbent in power, or I was only trying to make sure that my party would have more seats. That never should be a legal basis for drawing districts in our country.
I agree with you 100%, Barbara.
Yes.
State constitutions. What role do you believe state constitutions play in protecting voting rights when federal protections fall short? So what role do state constitutions play? And do you know of any state level court decisions that bolstered or weakened these protections?
Well, it's fascinating. The biggest issue for the legal system in the United States right now is, how do you keep partisans, ideological partisans, from making decisions and interpretations regarding voting rights and limiting those rights? A good example is North Carolina, right? In North Carolina, you've had, several, Harper case, you've had all these cases that have gone up to the Supreme Court. And interestingly, you have seen just the difference of one person on the Supreme Court tip the balance of how decisions are being made about interpreting state constitutions. So you saw that horrible instance where in North Carolina, you had the court hold that certain laws like the voter ID, et cetera, were discriminatory, and then turn around with with one new person on the court creating a new majority, invalidating its own decision. Who ever heard of such a thing? The court turns around within 2 years and invalidates its own decision because it has a new political direction. So that to me has been horrifying to watch. I've loved watching the Pennsylvania courts. I've loved watching a number of courts that have used state constitutions to create broader rights. But when you see a political flip, and it's totally based on ideology, where all of a sudden people's rights of those who are, formerly incarcerated are switched, the rights of those who don't have, state-issued voter ID is switched, all kinds of other issues being more limited in the court's interpretation. Then you have to worry about how ideology drives decisions, even at the Supreme Court level, where you have a super majority of conservative justices that are making terrible rulings when it comes to, and I would say retrogressive rulings when it comes to voting rights.
Okay, so when we start talking about retrogressive decisions, and we can talk about or think about recent decisions in federal circuit courts, or we can talk about the disenfranchisement that is happening with felony disenfranchisement laws, or we can talk about how states are dealing with and regulating mail-in voting or absentee ballots and all of that. And it reminds me of the Jim Crow era. It's almost bringing that back in some ways. Do you see any legal documents or arguments being recycled that can kind of justify the modern forms of voter suppression? It seems like folks want to justify how things are happening. So while we can't sit here and justify the Jim Crow era being revisited in terms of voting and all of that, what are we doing? How are we, as lawyers, as legal organizations, how are we exercising our roles in making sure that we are not going back to legal doctrines that undermine marginalized?
Whoa, that's a big one, Cynthia, Dr. Swann. That's a big one, question. First of all, everyone, uh, when we saw the court's decision in 2013 in Shelley versus Holder, that decision, which I've taught many times, is a horrible decision in the sense that it already stepped away from traditional, what we would call jurisprudence in the voting rights area. So when they decided Shelby versus Holder and used, very and basically overruled Kassenbach, right? South Carolina versus Kassenbach, but didn't overrule it. Didn't say they were ruling it. Didn't even say they were, quote, distinguishing, just said they were reaching a different conclusion. Anyway, when they did that and they walked away from looking at racially polarized voting, they just say, well, look, Obama got elected, but they did not look at the racially polarized voting that went underneath that election. They just said, well, he got elected. That shows that we're better than we used to be, so on and so on. I mean, when you can play those kinds of games with legal principles, that's when we get dangerous. It's very important that if you're going to overrule a case, overrule it. If you're going to distinguish the case, distinguish it on good jurisprudential grounds. Don't stand around and pretend that you're doing the same as the other courts would have done. Be true to the fact that you're now taking a radically different direction. We saw that in this affirmative action cases. So I think that we're still dealing with the same old ugliness that we saw not only in back in the in the past, in many cases like Ferguson, but we're seeing even worse. We're seeing these this racial denial at a new level. And at the same time, we got all this hostility that people just believe that they don't like the changing demographics of our nation. And they're returning to second-class citizenship ideas. I mean, I would say that if you really look at Vonovich, where it talks about, well, there's, even though this measure might, be discriminatory, or, it may, create blockades and barriers for voters. Well, at least they got another, alternative. That's separate but equal, right? Again, resurrecting his head in a different, kind of context. It's no longer, saying that it's on the basis of, blacks being, inferior, but it's saying that that somehow there's you can a discriminatory measure isn't by itself a reason for striking it down if there's a, quote, alternative. That's bad law. There's just nothing.
Reframe it.
Vonovich needs to be totally struck down and redone. It's just contrary to any modern principle. I also see, but that resurrection of the idea of second-class citizens is really troubling, because that's what you're seeing in the popular discourse, the popular public debates, that people just believe that if you are, a recent immigrant who's become legal, they believe that if you are not white, that you somehow aren't the same as a white citizen. That should have been resolved back in the Reconstruction Amendments, right? But we're back to that kind of philosophizing, and people are buying it. I mean, they're buying it. If they didn't buy it, they wouldn't believe that Haitians are eating cats and dogs. I mean, all this stuff is the result of a whole embedding of what we call the white replacement theory. I think we're seeing it come through some of these court decisions, and I'm concerned about it. I mean, I thought the court, when it decided Allen versus Milligan, the second congressional district case out of Alabama, that the court was beginning to try to tilt into a new direction. But then when I saw Alexander, I said, no, They're still going in the wrong direction, and that it's important for us to understand that we, as lawyers, have to really stand up differently when it comes to our democracy. I absolutely reject 100% and will debate anybody about it, that when it comes to democracy, that lawyers should have a hired gun mentality. You know, people say, hey, I'm just a hired gun. I do what my client pays me to do. It doesn't matter, you know, as long as they're paying me and I got a, you know, a legal basis, I'm going to make an argument to win for my client. But when it comes to democracy, we as lawyers, all of us, our first priority should be the upholding of our democracy. Lawyers should not do what we saw them do in 2020 and in 2022. We shouldn't be seeing all these frivolous, baseless cases being brought to deny voters their voting rights, and cases that were so bad that court after court said that the very legal foundation of the cases was lacking, that these were cases that were just, you know, clogging the courts up, delaying processes, trying to make it harder and more confusing for voters. That should not be the role of lawyers. I think lawyers have an obligation to not be assisting anti-democracy forces. I just don't believe in that. I mean, let's have a real democracy always, where you allow the exchange and the battle over ideas to prevail. It shouldn't be that you block and you use these legal skills that you were entitled to acquire to actually try to deny people their basic citizenship rights. I am really disgusted with a whole large part of our bar that has engaged in these activities. Fortunately, I shouldn't say large part, it's a minor part, but I'm still concerned about it. I'm concerned about what are our law schools teaching. I'm concerned about what's going on, but I am proud of the bar associations that post 2020 have held lawyers accountable for having misused the courts. And I'm praying that we don't see a lot of that abuse again in 2024. And I know that's kind of, you know, a hard line, but that's what I believe.
Well, and that's why you're here. We wanted to believe, and we wanted your voice in this critical area, because obviously there's a need to hear both sides. There's a need to understand where the energy is, especially in our marginalized communities and our BIPOC communities. The voice of the concerns have to be raised, and the expectation of us as professionals, legal professionals, need to be brought to the fore. As we look at the securing voting rights for future generations, and as we have, and hopefully many of our young lawyers will be watching this chair chat and hearing what has been put to them as, this is what you need to do as attorneys. You need to care about the democracy. You need to defend democracy. You need
exactly.
to democracy. As we're looking
I mean, Cynthia, just think about it. If you were in the medical profession, you're taught to heal, right? You're taught to treat people and to heal people. You're not taught to deny that service to anybody. If somebody comes into your clinic and you are providing services, or your hospital, you're providing services, your obligation is to provide those services. And you don't sit around and say, oh, I don't like them. I think they're an immigrant. I think they're a migrant. I don't like the way they vote. I don't think they should vote it because they are different and they, you know, have too liberal, and I don't like their, you know, they don't do that. They shouldn't do that. That would be malpractice, right? As a medical profession, to deny somebody's services. So how is it justified that lawyers can say, well, they pay me, so I say whatever they want said, even though I know it's harmful to the democracy? That's just, there's something very wrong there when we are a nation based on constitutional laws.
I agree with you 100%. I will say to you, and I know you know this, that, quite frankly, the courts are leaning into the role of the medical professional. And actually, especially with Roe v. Wade, and you name it, they're
You
telling
got it.
that the recent Texas
You got it.
went to, you cannot provide emergency
You got it.
abortions,
And,
and
and, and
and
that's wrong, right?
what I think about abortion, but what it goes to is the fact that a medical professional should be able to say whether this is a life-saving
Right.
procedure, whether it's abortion, whether it's whatever it is, appendectomy, whatever it is, and not
Yes.
guessed by legislatures. But that
And
is happening. So
because of ideological legislatures and ideological courts.
exactly. And we
Yes.
are in dangerous territory, both in the law
Yes.
and medicine. Um, if you were wanting to discuss the legal reforms that are needed to secure voting rights for future generations, um, would you say that a constitutional amendment related to voting rights would be a viable solution, given the hurdles that we've already seen with Shelby?
I think that the most vital thing that should happen in our country is the passage of pro-democracy legislation. I think we need the immediate passage of the John Lewis Voting Rights Advancement Act. I think we need immediate passage of the Freedom to Vote Act. I think we need immediate passage of the Native American Voting Rights Act. And I would also advocate that we need the passage of the DC Admissions Act, because there's no reason why over 700,000 people in our country should be not denied the right to choose a congressional representative and senators of their choice, and to have neither in a governance, a representative governance, and a Republican democracy is just unacceptable. And so I think that if you pass the John Lewis Voting Rights Act, then states with histories of voter discrimination would have a higher level of scrutiny that would go into the actions that they're taking. If you pass the act that's being proposed, you would have a notice requirement that when a state is about to change a major law, that they have to notify the citizens. You would have presumed, practices that are illegal, like closing polling places within 10 days of an election, or you would have certain scrutiny that would be greater on certain known practices that are disenfranchising in their operations. That's the John Lewis Voting Rights Act. That's why we need it. If you have the Freedom to Vote Act, you have a set of uniform standards. The worst thing in the world is our poor people in all these different states not knowing what their rights are, because their rights to vote vary from state to state. So if you are formerly incarcerated in Illinois, your rights are totally different if you are formerly incarcerated in Arizona, formerly incarcerated in Florida, formerly incarcerated in Iowa, formerly incarcerated in Minnesota. That's why, Dr. Swann, there are 18 million people. I didn't say 8, I said 18 million people in the United States who are formerly incarcerated, who do not register to vote, do not vote, because they're afraid of going back to jail for illegally voting when they are actually eligible to vote in their states. But they have no clue what their law is, because it varies from state to state. Even if they move from one state to another state, their legal rights vary. So that to me is an example why you need the Freedom to Vote Act. You need uniform laws where people are clear what their legal rights are to vote. You need not only that, you need standardized early voting. Do you realize that there are states in this country that still don't have early voting? None, folks. You gotta have, you gotta be real sick, hospitalized to get some kind of absentee ballot to, possibly vote. But then Alabama's a good example. They have no, quote, early voting. And they only have, in-person absentee, very, very limited. If to that degree, they don't even really have that. It's very limited. Yet they made it illegal by SB 1, passed everyone this year, 2024, a law that says that if you are not the child, the husband, the wife, the spouse, that is, of a person, if you're not their their legal guardian, that if you assist them in filling out an absentee ballot request, if you assist them in sending out a ballot, if you even so much as walk it to the mailbox because they can't, they're not immobile and can't get out of their bed to take it to the mailbox, that you have committed a crime. This is, not only do you not have early voting, you also criminalize voting assistance, which the 1965 Voting Rights Act tried to provide for. So you got all these, problems. I mean, I'm dealing with cases where they're changing voting locations that were accessible to people who were disabled to make them inaccessible. I mean, talk about they're going to have these mobile units without ramps. Are you kidding me? Talking about, and steps, and people can't walk up them. I mean, this is insane. But this is our 2024 reality, that we are seeing these kinds of actions. So that's why you want the Freedom to Vote Act, because it would set uniform standards for every single state when it comes to federal elections. So no matter where I live, Alaska, Maine, California, DC, Georgia, wherever I live, I know I have the same federal voting rights. When it comes to federal elections, to congressional, to Senate, to president, I know I have the same voting rights. And the beauty of the Native American Act, the Native American Voting Rights Act, most people don't realize that on many reservations, because of the widespread distance between homes, guess who doesn't deliver mail on a daily basis there? Try our United States Postal Service. Guess that some of these homes don't even have, quote, allocated addresses to receive mail. So what are those people going to do when it comes to mail-in voting? What do you do when you live on a reservation where they're not making your rights, as the same as everybody else? Where you have to drive. I mean, we actually have had cases that we litigated, and one where Native Americans were required to drive 40 miles to the nearest polling place. Come on, folks, 40 miles. Are you ready?
And then there have been cases where when they get there, the polling place is located in a police precinct, which automatically causes concern, confusion, and folks will decide not to do it, or they'll get to the location after all of that for someone to say they don't have the right ID, they don't have whatever, which should not have been a requirement in the first place. So there's so much that is happening. So much
and no language interpretation, right? Exactly. No language interpretation. I mean, there's so I really support strongly, all of these laws. DC emissions is there's just no answer in this country for people paying their taxes like everybody else. Otherwise being a, quote, an American citizen, but being denied the right to vote for a congressional representative with full voting rights, or denied the right to vote. Otherwise, it's just wrong. And
Well,
I just think
Texas
that
without
we got to
representation.
do better. Huh? Yes, taxes without.
Representation is a huge issue.
Yes.
Robert, now you are on top of everything else, a huge grassroots activist. I mean, the Transformative Justice Coalition, the work that you do, I would like you to, at this point, bridge the gap, the conversation between legal theory and lived realities of marginalized communities as they are affected by civil rights and voting laws, but also the legal wins. How do they hold if we don't have a parallel movement on the ground? Activists, frontline activists that are equally as passionate about not only gaining, but sustaining and enforcing the rights once the legal victories come down. How is that working? How is that going to work?
It's terrible in many respects. I sit in a position, as you know, where we go around the country. I spend the last couple months, 50% of my time has been on the road, around this country, working with, groups on the ground. The reality is that groups are suffering. There's no money. It just drives me crazy. People don't invest in the groups that are out there doing this work. So you have the underinvestment. It may be that there will be some floodgating, possibly, as you get into the last 2 weeks of the voting. I have no idea. But that's been a traditional problem. So I see groups with great capacity, great, great, ideas, great planning, great ability to execute, who are underfunded. I see it every single day. It's just true. And so that's a real problem, because what that means is that I was horrified in my recent trip to Pennsylvania to discover whole Black townships where they have not had one literature drop by anybody, not one door hanger on anybody's door, not one yard sign anywhere, not one canvasser in any community. I mean, have not walked the streets, no robocalls, nothing, folks. No, phone banking, nothing. It's horrifying to realize that in a state as key as Pennsylvania, for everybody's sake, that nobody has contacted these townships. So that is, of course, something I immediately have been on top of, and talking to all the groups, everybody I can, to change that situation around. But it just shows you that there's this disconnect between people's desire to vote and actually making it possible for people to even have the basic information to vote. I mean, I was horrified, and I'm glad that we were there to do that. We were there in Pittsburgh and in and affecting those surrounding areas to actually motivate people to vote, to make them voter aware, to give them the materials they need to do that. So that disconnection really bothers me, because the people, I wouldn't have heard about it unless the people were upset that they weren't getting that kind of outreach. They were mad because they were feeling like nobody cared about them, and nobody thought that they were worthy voters. That's the problem. We got to say to voters every day, you count, that we care about you, that your vote is important. That's the only way people really are able to be part of this democracy. And the one thing I love about voting day is that on election day, my vote is as good as anybody else's, if I'm allowed to cast it. You know what always amazes me, Dr. Swann, is that, think about it, when I go to vote, usually I have had to vote sometimes where the lines were super long, an hour and a half. And I talk to my white friends who live in predominantly white communities, and they have never in their life seen a long line. They don't understand what a long line is. And their reality and my reality and that of other African Americans, and really also those in low income communities especially, Their realities don't match. And therefore, when I talk about long lines, they think I'm making up some kind of fiction. They don't believe it because they have never, ever experienced such a thing. And their friends haven't experienced such a thing. And all the people they call who are white that they know have not experienced such a thing. It's not their reality, so they assume it's no one else's. And they can't bridge the thought that it could be this disparate across racial lines. It just makes zero sense to them. So when people say to me, Barbara, I don't believe in long lines. I've never seen such a thing. I'm like, yeah, because you're white. You know, and you live in a white community. And they say, yeah, that's true. That's true. I said, but you got to come and see what we see. The same thing that when I talk about voter ID, you know, people say, hey, wait a minute, you got to have an ID to buy a drink, buy liquor, alcohol, fly a plane, whatever. You know, they always say those things. But what they don't think about, and what I tell everybody is think back in your mind to 2005 in Katrina. Something the Hip Hop Caucus, of course, continues to bear the banner up for the people who were caught in that Superdome and who were caught there because, one, they didn't have cars. They were car poor. Which, what happens if you don't have a car? You don't have a driver's license.
That's right.
You know, so when if you are poor and you don't have a car, you don't have a driver's license. And there people are like, well, everybody has one. That's just not true. Everybody doesn't. There are 25 million Americans who don't have a legal age, who don't have a driver's license, and that's because of the fact that they are either in a neighborhood where even if you have a car, the car insurance is so high you can't afford it. It's all of these issues. And I feel, and people don't understand that because they think, quote, people are lazy. And they don't understand the real barriers because that's not their world. They have, if they want to go somewhere, they always have a friend who can take them. They don't understand not having friends who can take you places because they got to work and they can't get off work to take you somewhere. They don't understand why early voting is so important because if you work one, not to mention two jobs, people don't understand how hard it is for you to get off on one day of the year to vote, how important it is to be able to have opportunities to vote through a longer period. There's just these realities, race, class, income, that people just don't think about. And so bridging is part of, as we are all taught, is try to imagine yourself in somebody else's shoes. They're not lawyers. They don't know lawyers. Dr. Swann, the first lawyer I met in my life, I was 19 years old. I mean, come on, they're not living next door to lawyers. They don't have them in their families. They don't know. And when they're being denied the right to vote, they don't know where to turn to. Hopefully, we can make sure they all know about 866 our vote. But what about the fact that some of the people who call that hotline, how do they call us, Dr. Swann? They call us from somebody else's cell phone because they don't have a phone. People don't even think about being too poor to own a telephone, to be able to afford to pay a monthly telephone bill. People just don't think about it. But I talk to them on that hotline. And they're calling me saying, well, I'm calling from, the guy standing next to me in line from his hotline, from his telephone. And so when you say, can you give me a telephone number to call you at? They're like, I don't know. Possibly you can call me at my cousin's number. They don't, that's the reality, folks. I'm sorry. And it's just for us who have been so privileged to have gone to law school, so privileged to be lawyers, so privileged to have steady income, so privileged. We just need to imagine deprivation and the reality of what it means to be disadvantaged and marginalized in this country, and how bad they need us to be their advocates, not their blockers when it comes to voting.
Barbara, you have definitely really laid the groundwork and the framework that a lot of our members don't know, don't understand, have not experienced. What would be, as we close out, what would be the message, the request, the call to action that you would have for ABA members, for lawyers, judges? What is your message? What needs to happen in order for us to protect democracy, perfect democracy, defend democracy, ensure that voting rights are real, voter suppression is eliminated? What do we need to do? And what steps? How do we start? We have our Young Lawyers Division. They're eager and active to be engaged. What do? We have our senior lawyers who we know post-election we're going to need some experience to help work through whatever the outcomes may be. What is your call to action for ABA members, for state bars, national bar, for all bars? What is your call to action?
Have a mantra, have a life principle that is centered around protecting democracy. See democracy as central to everything. The Constitution is irrelevant if it's not centered in democracy. All of our rights are irrelevant. Constitutional rights don't exist if you don't have a real democracy. I just need people to really understand the centrality and the criticality of democracy. And what does that mean as lawyers? If you understand that, that means that you take every step you can to perpetuate democracy. Doesn't it occur to anybody that is odd in this country that we don't have democracy clubs? That that if you can join different groups, but they usually have multiple issues. But we don't have people who live 124/7 of their actual professional life is centered around democracy, that one principle. I just think that we need to do more in our country to build democracy. Those 4 laws I talked about, John Lewis Voting Rights Advancement Act, Freedom to Vote Act, Native American Voting Rights Act, DC Emissions Act, make those your causes. Be committed to the passage of that legislation and do what they did in Minnesota. Do what they've done in California. Do what they've done in other states. Pass state versions of those laws. Pass the AVR, automatic voter registration in your state. Get behind the laws that open the democracy, that expands it, that makes it accessible to all Americans. I also would urge you to become part of election protection. But also remember, I mentioned all those small groups that are underfunded. Give them, give funds, help support them, but also be their lawyers. A lot of these groups don't have lawyers. They call me from all over the country because they have no lawyers to call who are in their states. You might think that, hey, there's a whole lot of lawyers in the country. Yes, there are, but we're concentrated in certain states. We're not everywhere. We're not in every county. And some of these rural Black Delta counties in particular suffer from the lack of lawyers, the access to lawyers. Think about what you're going to do on election day. I mean, every day, one lawyer taught me this. He said, the most important decision you make in life as a lawyer is where you choose to be present. Mm-hmm. And he told me this horrible story about how he was one of the lawyers that was called to be at the White House when John Kennedy created the Lawyers Committee for Civil Rights. And he had a client, a commercial client who he needed to serve. And in his opinion, he needed to serve that client. So he didn't go to the White House. And he said, Barbara, that was decades ago. He says, and the only thing I remember about that day, because I don't even remember who that client was. Says, I don't even remember what the legal issue was that was so critical. He said, but what I do remember is that my president asked me to be president. I wasn't. He says, you have to, as an attorney, every day, think about where you're going to be present, how you're going to use the skills you have, on whose behalf, towards what end, towards what goal. Don't just exist. Have purpose in your meaning, everybody. That's for me. You have purpose in your meaning. Make sure that you are part of the change makers in our society, because our society can be better. And it's not without possibility. It's within our reach. We just got to do the work. We got to be out there. We got to have the faith. We got to have the ability. I travel, Dr. Swann, to many international contexts. I have been in authoritarian countries where I have had to stare down the barrel of rifles, walking into simple hotels, restaurants. I have had to have people, bully and push us forward, because that's the way they treat people in authoritarian countries who they don't, who aren't, members of the higher ups or whatever. I want people to understand we don't want to be that country. Democracy is precious. If you ever lived or been in an authoritarian context where you've seen people denied their rights, taken to jail for no reason, imprisoned, denied access to lawyers, if you've seen that reality, then you would fight like crazy for democracy, especially here in the US. You would do everything you can to preserve it, to promote it, to enhance it, to enrich it. You would never, ever turn your back on it for a dollar. You would never, ever turn your back on it because you forgot that you should be present.
Barbara, I cannot tell you how much I have appreciated this. This has been an incredible honor for me to be able to speak with you and to be in the same space with you. Thank you so much. And to our listeners, this is Ms. Barbara Arnwine, President and founder of the Transformative Justice Coalition, and an incredible, incredible scholar, legal scholar, and voting rights activist, community engagement activist, and a resource for you to always reach out to if you need to understand the rights around voting. Barbara, thank you.
Thank you. Thank you. Thank you to the president of the ABA. Thank you to Dr. Swann for all of your leadership. Thank you for this opportunity to be heard. Thank you.
Thank you.